So there are two key conclusions from the Supreme Court's judgment in the Miller case today on the triggering article of Article 50 and starting the Brexit process. First of all, by a majority of 8 judges to 3, the Supreme Court's decided that Parliament does need to enact new primary legislation to authorise the government triggering that Article 50 process and beginning the 2-year process of negotiation over our exit from the European Union with the other 27 European Union member states. What the court has roughly decided, or at least the majority of 8 judges have decided, is that EU law is effectively a new source of law in the UK's constitution, and that the royal prerogative, the government's power that it normally uses to conduct international affairs and ratify treaties, can't be used to cut off that new source of law. And Parliament cannot have intended, when it legislated in 1972 to take us in to the European Union, it can't have intended that their government could cut off that new source of law by ministerial action alone. So they say that, at least 8 judges of them say, there are 3 dissents disagreeing with that conclusion, but the court in its majority has held that an act of Parliament's required. The second conclusion then is in relation to the role of the devolved institutions in Scotland, Wales and Northern Ireland and their input to the Brexit process. And what the Supreme Court has held there is that there's no requirement that they consent that the courts can enforce. So they've considered what's called the Sewell Convention, a convention which says that where the UK Parliament is going to enact legislation which affects the devolved institutions and affects their areas of competence, that normally those devolved institutions in Scotland, Wales and Northern Ireland would have to consent to that legislation of the UK Parliament. But what the court's held here is that this is a political convention and it's not one that the courts, as a legal court concerned, as they put it, with the rule of law, can be involved in enforcing. So in that sense, while the government has lost on the question of whether an Act of Parliament is required and will now need to go to Parliament and bring forward legislation to give them the power to trigger Article 50 and begin our negotiation of exit from the EU, they've won unanimously 11 judges to 0 in the Supreme Court on the question of whether they need to have legally required consent of the devolved institutions. Of course, as the court recognises, there are still going to be important political reasons that the UK government has to take into account very seriously the positions of the devolved administrations, not least because in Scotland and Northern Ireland there was, of course, in the referendum, a different vote. They voted to remain, as opposed to England and Wales, who voted to leave in the UK as a whole. So those are the 2 key conclusions from the case today. But I suppose the next question is, well, where do we go from here? One thing that the Supreme Court has confirmed is that a short bill, a short Act of Parliament, literally just giving the government the authorisation to trigger Article 50 would be sufficient to satisfy the requirements of the case. So they've said that a short bill would be fine. So now the next step really is the political noise around that bill which emerges. And so the question is, well, will the other parties in Parliament, as the bill progresses through the Commons and perhaps particularly as well the House of Lords, will those other parties try and amend the short bill that the government's legally entitled to try and put forward? Will they try and amend that to write in a greater role for Parliament in the negotiation of our exit from the EU? One question might be whether in fact this will have any great impact at all. It doesn't necessarily seem that it's likely to prevent the triggering of Article 50. There seems to be a majority in the House of Commons certainly to vote in favour of beginning negotiations with the EU, and probably on the government's timetable as well by the end of March. There are also non-UK imperatives to get things moving quickly as well. If the UK wants to negotiate its withdrawal within 2 years and be out in 2019 before the next round of European parliamentary elections, which of course the European Union would quite like, then again we have to stick to the government's timetable quite closely. I suppose that one of the questions that will be asked today is whether the Supreme Court has given Parliament the opportunity to create a bigger role for itself in that process, and we'll have to wait and see about that. But of course it's also worth noting that, as some of the dissenting judgments in the Supreme Court note, Parliament has, through its powers of political accountability over the government, the right to try and involve itself in these processes regardless. And of course there was a major concession in Theresa May's speech, perhaps inevitably, but still a concession, that Parliament would get a final vote on the terms of the Brexit deal when we have actually negotiated our withdrawal from the EU. Whether Parliament can use the Supreme Court's judgment to improve its position yet further remains to be seen. But it's not beyond the realms of possibility that Parliament would have been able to write an even more significant role for itself into this process, even had the Supreme Court not decided as they did today.